From today on, make the rest of your life the best of your life. 15 USC 1692. Can we use it against a creditor? You are aware of how bothersome debt collectors may be if you have ever been the recipient of letters or phone calls from one of these individuals. There is a high probability that letters will demand urgent payment and will contain extremely little information regarding the origins of the obligation. When you receive a call from a debt collector, they will disrupt your otherwise hectic day and leave you feeling irritated. Under the Fair Debt Collections Practices Act FDCPA, which can be found in 15 United States Code 1692, customers are allowed to safeguard themselves against debt collectors. The Fair Debt Collection Practices Act FDCPA was initially enacted by Congress in 1977, and it has undergone multiple amendments since that time. Consumers are protected against abusive and harassing debt collection techniques that can hurt their mental and physical health by the Fair Debt Collection Practices Act, FDCPA. If you are aware of your rights under the Fair Debt Collection Practices Act, FDCPA, you will be able to recognize when the acts of a debt collector get out of hand and take the required steps to protect yourself. Debt collectors are prohibited from disclosing your debt to any other parties. When trying to get in touch with customers who owe money, debt collectors typically use the telephone. On the other hand, when someone who is not the debtor answers the phone, they are required to adhere to a set of stringent criteria. A debt collector is required to provide their name and initiate communication with the customer who is responsible for the obligation. It is not appropriate for them to disclose the identity of their employer unless the individual specifically requests that information. In addition, debt collectors are not permitted to assert that a consumer is in debt. The debt collector will not be able to get in touch with the individual again if they are unable to provide the debt collector with information regarding the consumer's location. The debt collector, on the other hand, can make another attempt to contact the individual if they discover a change in circumstances that may have resulted in the individual having new information. Because the debtor's financial problems will be revealed to anybody who sees the postcard, debt collectors are unable to engage with the debtor through the use of postcards. In addition to this, they are not allowed to include any words or symbols that are not enclosed in an envelope that indicate the message is about an outstanding debt. If a consumer decides to seek the assistance of an attorney to resolve their debts, the debt collector is required to cease all communication with the individual. All communications, on the other hand, are required to be sent directly to the attorney's office. When communicating with you, debt collectors are required to adhere to a set of strict rules. When approaching you over the phone, debt collectors are required to treat you with professionalism and courtesy. They are not allowed to call you at unreasonable hours, such as before 8 in the morning or after 9 in the evening in your time zone. Debt collectors can call you at work. However, they are required to stop making these calls if your employer requests that they do so. In addition, debt collectors are prohibited from divulging any information about the debt that you owe to any third parties. That means they are not allowed to inform your brother or grandmother that you owe money, nor are they allowed to urge your daughter, who is 16 years old, to get in touch with you about a debt. You, your attorney, the original creditor, and consumer reporting agencies are the only people who are permitted to discuss your debt with each other. Through the use of written notification, you can request that a debt collector stop communicating with you. The debt collector is unable to resume communication with you after receiving your letter, except to inform you that it is suspending collection activities against you or intending to invoke a particular remedy, such as debt litigation. It is illegal for debt collectors to harass or abuse you. It is against the law for debt collectors to engage in behavior that is abusive or harassing, as stated in 15 USC 1692. Every single one of the following activities is prohibited by the law. The use of physical force or other methods to cause you physical harm, damage your reputation, or cause damage to your property is a potentially harmful threat. Using vulgar language to abuse or injure you. Publishing your name in a list of those who don't pay bills. Advertising your debt for sale to convince you to repay it. Calling you continuously throughout the day. Failing to identify themselves when they contact you. Let's explore an example to illustrate what an abusive debt collector may act like. Example: Sally has an old credit card debt of $1,500. Tough Dog Collections buys the debt from her initial creditor and takes measures to collect the money she owes. Daily, Sally receives multiple calls from agents from Tough Dog Collections, frequently from a variety of different numbers. They send her mail with letters taken out from a newspaper. threatening to harm her reputation at her employer if she doesn't pay $1,500 in 3 days, when Tough Dog Collections publishes an announcement in her neighborhood newsletter, alerting all of her neighbors that she owes money for a credit card debt. This is the final straw that breaks the camel's back. Under the Fair Debt Collection Practices Act FDCPA, Tough Dog Collections has committed a major violation of Sally's rights. Considering that Tough Dog Collections has been abusive and harassing Sally, she can file a complaint against the company and demand damages as restitution. Debt collectors can't use fraudulent or deceptive techniques to collect an obligation. The Fair Debt Collection Practices Act FDCPA makes it illegal for debt collectors to call you while pretending to be someone else. They can't play the role of your long-lost uncle, an old ex-lover, a sheriff, or an attorney. It is also not possible for them to tell you that they will take a step that they do not have the authority to take, such as taking possession of your home or sending you to jail. Debt collectors also can't employ fraudulent techniques to force you to settle a debt. For instance, they can inform you they'll garnish your income starting next week if you don't instantly pay. To acquire a wage garnishment order, they are required to go through the appropriate legal channels. They are not permitted to seize your salary without any reason. The FDCPA also forbids debt collectors from engaging with you via letters that appear like judicial processes. If you get a letter from a debt collector that appears like a court summons or judgment, but is not, the collector has violated the FDCPA. 15 USC 1692 safeguards you from unfair debt collection practices. If a debt collector won't leave you alone, or if you feel their actions affect your mental health, they may have violated 15 USC 1692. You can either sue the debt collector or file a complaint with the Federal Trade Commission (FTC) against them. Punishments for violations might be as high as $1,000 for each transgression. Don't be afraid to stand up for what's rightfully yours. You might save other people from the same consequences. Are you facing a lawsuit for debt from a debt collector who practices abusive behavior? To defend yourself, you can use the debt answer template provided by SoloSuit. If the consumer notifies the debt collector in writing within the 30 days described in subsection A, that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of a judgment or the name and address of the original creditor is mailed to the consumer by the debt collector. Collection activities and communications that do not otherwise violate this subchapter may continue during the 30 days, referred to in subsection A, unless the consumer has notified the debt collector in writing that the debt or any portion of the debt is disputed or that the consumer requests the name and address of the original creditor. Any collection activities and communication during the 30 days may not overshadow or be inconsistent with the disclosure of the consumer's right to dispute the debt or request the name and address of the original creditor. 15 USC 1692, otherwise known as the Fair Debt Collection Practices Act FDCPA, establishes regulations protecting consumers from abusive debt collectors. Experts explain everything you need to know about the FDCPA so you can protect yourself from non-compliant debt collectors. Do you like it? Kindly give your valuable response in our comment section below. And don't forget to subscribe to our YouTube channel for more interesting and informative. I'm giving you some news you can use.